Welcome back to the show, everybody. Check out these headlines we have for you today. Senator Lummis crypto bill, the SEC filing to seal, still claiming it's a threat, but what's going to blow your mind is who it's against. Forbes, Rosalind Layton lays it down. The SEC forced to settle soon? We're going to talk about that. We're also going to talk about another issued court order from the judge this time. You're going to want that as well. And a straight fire show from John Deaton, Jeremy Hogan, J.W. Verrett, former advisor to the SEC, Eleanor Terrett from Fox Business News, and Jason Foster from Empower Oversight. You're going to want every single bit of it. Somebody roll that beautiful intro.
Digital Perspectives with Brad Kimes. Come on in.
Welcome back to the show, everybody. You can follow me on Twitter at Dig Perspectives at the top of the screen and everything that we're talking about here today. Right now, we are at $945 billion market cap, under $1 trillion now. I tell you, we are bleeding heavily still again today. We're off by 3.1%. Good morning. It's June 15th, 2022. Bitcoin, 21,200 plus. Right now, I'm sure MicroStrategy boardroom is having one hell of a meeting this morning. Ethereum 1100 plus right now. We see actual Cardano is at number 7 at 47 cents. And number 8 spot now is XRP at 31 cents. We're ranging between 30 cents and 32 cents. 3 for $1. Blue light special on crypto. Look, I'm also getting into this. You guys know I love fine art, okay? I mean, I admit it. I love it. And I have bought into many works on Masterworks, and you can too. But here's the beautiful part here. The gains from all these different similar works from these artists are crushing the S&P 500 right now. Now, is there a risk? Obviously, there's a risk with any investment, right? But I encourage you to click the link because it even goes up to 20 plus gains depending on the artist's work that you're getting into. So check all of this out for yourself. Another beautiful part to this, no minimums. $20 a share, and you can own shares to some of the most incredible artwork on the planet. Make sure you check it out. Let's start right here. We got a lot to go over today. More than 34 million Americans report owning some form of digital assets. Senator Cynthia Lummis says we're regulating this 21st century technology with the 20th century regulations. It's time for an upgrade, and the Lummis-Gillibrand plan accomplishes that. Now, we will see. We'll talk later, and we're going to hear from J.W. Verrett, former SEC advisor, speak very clearly towards the bill. And I love what he has to say because, as I've said, there are some very good things in this bill, but there are some areas in this that are still just as vague as the gentleman you're about to hear from. It's Gary Gensler right here. Someone is taking a step back, says Costa Rica Kelly right here. So take a listen to this clip.
Raising money from the public, and the public's anticipating a profit based on some group of entrepreneurs. That's a security, and the public needs to be protected, and that's what Congress said. That's not what we're saying. There are some small number of tokens that predecessors talked about that may not meet that test that are commodities, and they may even have a large percentage of the crypto market. But for the bulk of the tokens in the market, the bulk of the numbers of tokens, they have attributes of securities, and that protection is important. We look forward to weigh in on this, but in the meantime, Bob, we're going to use the authorities we have. We're not looking for any additional authorities. We're just use the authorities we have, whether it's on crypto tokens, most importantly, the crypto exchanges and the lending platforms. We've seen again that.
Now, there is him, Gary Gensler taking what appears to be a step back. But really, I believe what we're really witnessing is he's getting closer to saying in public what he's been saying privately to congressional officials, is that he understands Bitcoin and Ethereum to be commodities, and then everything else falls underneath his purview. We'll get into more of this in just a second from J.W. Verrett here. Now, looking at this, there are a couple things we need to go over today. The first thing we're going to start with right here, shout out to Jim Filan right here. The SEC has filed under seal a redacted version of the brief and its exhibits opposing the amici motion to participate in the Daubert challenge. It's now up to District Judge Torres to decide what will be public and what will remain under seal. So let's understand more what's going on here, because what they're claiming, obviously, in their filing was that there is a threat to the expert witness because there's so many people in the crypto space that are angry about the lawsuit and XRP possibly becoming a security, right? But it gets worse. Mark Phillips says here, so now the SEC and its paid witnesses are the victims? Ripple has spent $100 million defending itself, and tens of thousands of innocent XRP holders have been financially harmed by the SEC's willful impropriety. Tell me again, who are the victims here? I tell you, Mark Phillips has got his thumb on this. Oh, man. And I tell you, if you look at what James Filan had shared here, the SEC filed its request to seal its response to the amici motion to participate in the Daubert challenge. The SEC claims that while some information the SEC seeks to seal has already been publicized by Movent's counsel, John Deaton. So basically what they're saying in this is that John Deaton is the problem, is what they're saying. The SEC seeks to seal this and other material to prevent further threats to and harass the SEC expert. The SEC further states that the expert witnesses understand that their opinions may be challenges by opposing parties and may even expect public challenges to their opinions in high-profile cases. But no expert witness should expect to be subjected to a campaign of humiliation, harassment, or threat simply by agreeing to act as an expert witness. Now, if we get into this, Jeremy Hogan comes to the rescue here and say Deaton may have commented on the SEC's expert witness. That is fair, desirable, and something that people should do, even if the commentary is negative. But the SEC's conflation of Deaton's comments with harassing and threatening statements others may have made is just ridiculous. I don't even have to read. I'm not going to even read these things because Jeremy says it best. It's ridiculous. And you know what? This is just one more ploy by the SEC to delay and try to divert what the real problem is. And I'll tell you who nails it here. It's Rosalind Layton. Shout out to you, Rosalind. Judge Netburn may order the SEC to provide internal documents on Hinman's infamous speech. This could expose the SEC market deception and force a settlement with Ripple. How about that for a notion? And how about this? Because the whole article is incredible, and I would read it to you, but we got a lot more to go over, and Rosalind is amazing. And believe me, she's got this thing figured out. Let me take you to this section. Transparency could expose SEC fraud. The SEC has fought transparency requests on the genesis of Hinman's speech relentlessly, the revelation of which could expose potential agency fraud. Innocent XRP holders lost $15 billion in value and entered the case as friends of the court against the agency. The crowdsourced documentation showing Hinman had multi-million-dollar financial interests in a law firm promoting Ripple's competitor Ethereum. Hinman's speech could have been a revolutionary turning point for American innovation, but it became an unmitigated disaster. Not only did Hinman deceive the public and materially harm thousands of investors, he and his cohorts brought severe damage to the SEC's credibility and integrity. The SEC made a mockery of its mission to protect investors. However, regulatory scholars are not surprised. They have demonstrated over the decades that captured agencies like the SEC favor their preferred players like regulated banks over innovators and consumers. With increasing regulation, Congress has made the problem worse. Now, the only backstop is the courts, where aggrieved innovators attempt to get a fair shake. Magistrate Judge Sarah Netburn may order the SEC to end its obstruction and provide the internal documents on Hinman's speech. This could expose the SEC's market deception and force a settlement with Ripple, the first step of a long overdue reckoning for the agency may be at hand. I think you're looking at what should be a Pulitzer Prize, to be perfectly honest with you. Rosalind, this is remarkable journalism. Shout out to you. No doubt about it. Here is the other court order issued by the judge herself. Judge Netburn uses the word may. Is this unusual? I haven't seen a response from any one of the legal analysts as of yet. And I'm curious too, because I asked the question as well. And shout out to, who was it? British Miss. So shout out to them for picking up on as well. Let me read this court order from Sarah Netburn to you. It says the court previously permitted the SEC to submit 10 exemplar documents for in-camera review in connection with its motion for partial reconsideration of the court's January 13, 2022 order on the basis of attorney-client privilege. The SEC seeks to withhold these and other documents described from the February 17, 2022 motion for partial reconsideration. The court has reviewed the 10 exemplar documents previously in the context of the deliberative process privilege, but has not reviewed any of the documents listed in Attachment 1. To facilitate the court's review of communications to which the SEC claims attorney-client privilege applies, by June 16, 2022, by tomorrow, the SEC may submit 10 additional documents listed in Attachment 1 for in-camera review. So may sounds like it's subjective. Like if you choose to put some more information to your benefit, you can submit 10 additional documents. So we'll see. So this is really interesting stuff going on here. Now, this is Louis Cohen, who was on Laura Shin's show, and he says he doesn't think it's a great idea to accept this morphing concept of a safe harbor, basically, of you start out as security, you're not a security. Listen to this quick clip, because you're going to hear J.W. Verrett, former SEC advisor, speak to this very soon.
The challenge with the safe harbor is twofold. Firstly, it embraces what some people refer to as the morphing concept, the idea that a digital asset can start life as a security, then based on things entirely extrinsic to the digital asset, later but no longer be a security. And then later, if it sort of other things happen, the asset would re-become a security. This is a concept that's just not supported in the law, and really upon any extended thought doesn't make a lot of sense. Assets don't change their character based on extrinsic factors. So I don't think it's a great idea to embrace this morphing concept.
So he doesn't like the safe harbor morphing concept. Now, let me give you this right here, because I want you to have this. This is John Deaton on fire here. Check it out. Here we go.
On this speech, instead of giving this speech, why didn't they just adopt that safe harbor where it said you have 3 to 5 years to meet these markers? And hey, Ripple, if you don't meet these markers, or ETH, you don't meet these markers, then you have to register. If you do, it is, great, and you go on and you're sufficiently decentralized or whatever language. Why was that not adopted under Chairman Clayton? He had the votes. He had Elad Roisman and he had Hester Peirce. I don't know. Do you know the answer to that question?
That is a remarkable question right there. He had the votes. Why didn't he do it? Listen to this.
I got to pass that one to JW. I don't know. I mean, obviously, I think you're going to talk more about this later, but, obviously I think that it's come to be that we know now that Mr. Hinman probably had some ulterior motives for that speech, maybe jumped the gun and didn't have the backing that maybe he needed in order to really get the commissioner's views out there.
Ulterior motives. We know now. Yes, we do. Keep listening.
But I don't know.
JW, any thoughts? I know you have a hard stop soon.
Sure. I know Jay a long time. I disagreed with him on his approach to crypto. Believe me, I had a lot of private conversations with him during the ICO era where I said, I don't like some things happening in some of these ICOs. I love to get a crypto-specific regulatory regime. Hester's safe harbor hadn't been out yet. I wish it had. I would have been arguing for that. But I had a lot of tough conversations with him because it was the one area where I just glaringly disagreed with him. I don't know Hinman. I don't know what Hinman was about, so I can't tell you that. I think Jay's heart was in the right place. I don't think he had any nefarious intent. I think he was just risk averse. It was a new thing, and he was a classic regulation guy, and he didn't want to try anything new. And it was a mistake, and it was the wrong decision. I don't think there was anything unethical about him. I just don't know Bill. I mean, I don't.
And before we go on, and I don't know anything about Jay Clayton, but I know for somebody who maybe was so risk adverse, went on to work for Apollo Group, didn't he? Just saying.
I don't like the optics of what happened here. What I've seen so far from what Empower has taken out, it seemed like he didn't comply with the ethics requirements, and that's a problem. I don't think that's on Jay. I think that's on Bill. I don't know why. I don't know why he didn't do more. Give us the guidance and the clarity that we need. I wish they had.
Well, listen, I thank you both, JW.
And there you have that, but we're not done because listen to this. This is John Deaton laying down straight fire. And if you ever wanted to know what this is all about, here it is on a platter.
This ethical legacy that is very active, that's lingering, that when Bill Hinman gave this speech, you all saw the chart and you heard Jeremy Hogan say, scratch his head. Why did they gratuitously, all of a sudden, one day, they'll never talk about a token. They'll never talk about a specific platform. But on June 14th, 2018, Bill Hinman's going to get up on that stage and he's going to say, Bitcoin is not a security. ETH is not a security, and talk about these things and then never address another token thereafter.
Now, think about that point that he just made. We always hear Hester Peirce, Gary Gensler, anybody, Jay Clayton. I can't talk about any one specific token, but that's exactly what William Hinman did on that day. That is exactly what he did.
Why? Because from that moment, you scratched your head. Like, why are they singling out Ether? It had an ICO. He said, well, forget the fundraising, but how does it apply to any other token? And we never got answers. And so people started asking questions. People started looking into these potential personal conflicts. And it's fair to say that in this case, there are what I have called massive conflicts of interest and gross appearances of impropriety. We're going to talk here in a minute, but I want everyone to take a look at this email from the person in charge of the ethics office at the SEC to Bill Hinman. This is courtesy of my next guest, Jason Foster of Empower, but read it. Right? It lets him know you have a bar under the criminal financial conflict. You are not allowed to even talk to Simpson Thatcher. And what did Bill Hinman do? He met with them 3 more times that we've documented from after receiving this stern warning that he could be in violation of the criminal conflict laws of the United States.
Straight fire. And to back all of that up, we have Eleanor Terrett from Fox Business, Jason Foster from Empower Oversight talking about glaring conflicts of interest. Watch this.
I'm not saying that there's, like Charlie and I always say, I'm not saying that there is any kind of corruption here. Charlie says confluence doesn't equal causation. But I will say, after many months of investigating it and writing about it, it's clear that there are many conflicts of interest here. And it's not just Bill Hinman, but Bill Hinman has, as it would turn out, as it appears from these documents that Jason and Empower have turned over, have gotten for us, it's pretty glaring, especially with the communications with Simpson and Thatcher. I will say, when I first saw that, I kind of thought, maybe these meetings with his friend from Simpson and Thatcher, Josh Bonney, could be very casual, just going out to lunch, just catching up as friends. We don't know their, personal background together. We don't know if they were talking business or if they weren't. But you have to go back and look at the emails from the compliance office saying, Bill, you have a financial interest in this company and you cannot have any meetings with them. So that, to me, is just very, that's glaring. And, I know Jason has some thoughts on it as well, but there's lots of things going on here. And I feel like there's more that comes out every day. And I'm personally interested to see what other documents the SEC is going to turn over, because, with the Freedom of Information Acts, we are, on the road to something pretty big here.
Kelly alluded to something. She alluded to that you've learned and others have learned that through the FOIA request that you issued and have litigated, that it was determined that this wasn't a regular pension that Bill Hinman was receiving, but he was an active, ongoing profit-sharing partner, which meant the better the firm did that same time, simultaneously, that he's an officer at the SEC and a government employee, that he has a ongoing financial interest. Is that my understanding correct?
Yeah, that's what we learned from the documents when we, when we finally got the SEC to actually start turning them over, which of course we weren't able to do until after we filed our lawsuit.
And there you have it right there. Here's what I know, and you don't have to be a lawyer to understand this. If we go back to very quickly here, this order issued by Judge Netburn, saying that the attorney-client privilege issue, and that if the SEC may submit 10 additional documents from the Hinman email drafts, may submit 10 additional documents, sounds like to me, before I issue a ruling, if you want to bring me more documents that may help aid your side of the case and your argument, you better do it by tomorrow. Now, I find that to be extremely interesting, because what I also believe is that if the SEC does not turn in any more documents, then the rest of those documents are more damning than the ones the judge already has. Make sure you hit that like and subscribe, leave a comment below. I'll catch all of you on the next one.